If you have a pending immigration application right now, an I-485, an H-1B, a family visa petition, or any pending case with USCIS or the State Department, I need you to stop what you are doing and watch this video completely. Because between January and March of 2026, 5 major policy changes took effect, and together they have created what I am calling a perfect storm for immigration applicants. A situation where a case that looked secure 6 months ago may now be in a completely different position. This is not speculation. This is not fear-mongering. Every development I am about to walk you through is fully documented, officially published, and directly traceable to federal agency action. The question is not whether these changes happened. They did. The question is whether you know what they mean for your specific situation. That is exactly what we are going to cover today. My name is Raymond Crivello. I am a senior immigration analyst and consultant. And on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand and act on. I do not chase headlines. I do not sensationalize policy. What I do is read the actual Federal Register entries, track USCIS operational updates, monitor State Department announcements, and translate all of that into language that makes sense. Whether you are an applicant, a petitioner, or someone who simply cares about the future of this process, I am not your attorney, and nothing in this video constitutes legal advice. This content is for educational and informational purposes only. Every immigration case is unique. Please consult a licensed immigration attorney or accredited representative about your specific situation. All right, let us get into it. 5 policy changes. What happened? Who made the decision? Who is affected? And what you should do about it. Let us start with the biggest structural change. Presidential Proclamation 10998, which took effect January 1, 2026, suspended visa issuance for nationals of more than 19 countries. Some countries face a full suspension. Others face a partial suspension affecting specific visa categories. Now, when the president issues a proclamation under Section 212F of the Immigration and Nationality Act, it is not a suggestion. It is a legally binding directive that immediately alters what the State Department can and cannot process. Consular officers do not have discretion to override it. What this means practically, if you are a national of one of these affected countries, or if your petitioner is, any pending visa application at a U.S. consulate abroad may be frozen, not denied, but frozen, without any timeline for resolution. The applications do not disappear, but they enter what is effectively a legal holding pattern. And here is what I want you to understand about holding patterns. They are expensive, they consume time, they complicate employment authorization, and they can trigger downstream effects on dependent family members and associated status holders. But here is where this becomes critical. Even applicants who are not nationals of the listed countries may be impacted. If your petition involves a co-applicant, a derivative beneficiary, or a sponsor who has ties to these countries, the suspension may create complications for your file. The proclamation's reach is broader than many applicants initially realize. 3 weeks after the presidential proclamation, on January 26, 2026, the State Department announced a separate pause on the issuance of immigrant visas for nationals of 75 countries. The stated rationale is what I want you to pay very close attention to: financial self-sufficiency. The State Department introduced new financial review requirements tied to immigrant visa processing, and while those rules were being operationalized, they paused issuance to avoid processing applications under outdated standards. That may sound administrative and routine. It is not. What this pause means in practice is that families who were waiting at the final stages of their immigrant visa journey, people who cleared the National Visa Center backlog, completed their medical examinations, paid their fees, and scheduled their consular interviews, may now be waiting again, for an indefinite period, after years of waiting. This is what many immigrant visa applicants are misunderstanding right now. The pause does not mean the visa is denied, but it creates real-world consequences: expiring medical examinations, employment offers that cannot wait indefinitely, family separation that extends for unknown additional months. The Administrative Procedure Authority under which this was issued gives the State Department significant discretion, but it also invites legal challenge. Several immigration advocacy organizations have already signaled their intent to challenge aspects of these pauses in federal court. What the outcome of those challenges will be and the timeline remains genuinely uncertain. Let me put a human face on this, because these are not just policy abstractions. Consider a family, The Raza family. A U.S. citizen petitions for her husband and 2 teenage children. The I-130 is approved. The case moves to the National Visa Center. They complete all the forms, pay the fees, submit their financial documents, and finally, after 2.5 years, they receive their consular interview date in early February 2026. Then, the January 26th pause hits. Their country is on the list. The interview is canceled. Their children's medical exams, already completed and paid for, have expiration dates. The family is now paying for legal advice to understand whether those medicals will need to be redone. The emotional cost alone is immeasurable. The Raza family is not a unique case. Right now, across dozens of countries, tens of thousands of families are in exactly this position, and they deserve clear, accurate information, not panic and not false reassurance. If you are in the employment-based immigration space, this one is for you. And even if you are not, I want you to hear this, because it affects the entire skilled worker ecosystem in the United States. Effective February 27, 2026, the H-1B cap season is operating under fundamentally new rules. 2 changes in particular are rewriting the entire landscape. First, a new supplemental fee of $100,000. That is not the base filing fee. That is a new additional charge, layered on top of existing processing fees, that employers must pay when sponsoring H-1B workers under certain conditions. For small and medium businesses, this is a serious barrier. For large employers, it is a significant cost shift. Either way, it changes who can realistically sponsor workers. Second, the lottery system itself has been modified toward a wage-based selection model. Under this framework, USCIS would give selection preference to registrations for positions offering higher prevailing wages. The intent is to prioritize the highest-paid, highest-skilled workers. The effect is that entry-level and mid-range H-1B positions face dramatically reduced odds of selection. There is one detail most people are missing about this change. The wage-based model, if fully implemented, would disproportionately impact industries like hospitality, retail management, mid-level technology services, and healthcare support roles, positions that have historically relied on the H-1B program precisely because U.S. workers are not available in sufficient numbers. The policy signals a prioritization shift that will take years to fully manifest in workforce data, but the application impact is immediate. If you are an H-1B applicant this cycle, or if your employer is considering sponsoring you, the strategic calculus has changed. Salary matters more than it ever has in the lottery context. On March 1, 2026, USCIS implemented a new fee schedule for premium processing requests. The Form I-907, which allows applicants to pay for expedited adjudication, is now more expensive. For context, Form I-140 immigrant petitions and Form I-129 non-immigrant petitions, 2 of the most commonly premium processed forms, now carry a premium processing fee of $2,965. That is a meaningful increase from prior rates. I want to be direct about what this means. Premium processing is not a luxury purchase for most applicants. For many people, particularly H-1B workers facing cap-gap situations or employment-based applicants racing against expiring work authorization, premium processing is the difference between maintaining legal status and falling out of it. However, this protection may not be sufficient on its own. Even with premium processing, USCIS has the authority to issue requests for evidence that extend the timeline well beyond the standard premium processing window. The fee buys you a faster initial decision, not a guaranteed approval, and not immunity from complications. The 5th development is the one that I think has received the least attention given its human impact. On January 14, 2026, DHS terminated the categorical family reunification parole programs that had provided temporary authorization for certain nationals of Colombia, Cuba, Haiti, and Ecuador. These programs allowed individuals who had approved family petition beneficiaries to enter the United States temporarily while awaiting their visa availability dates. It was an imperfect solution to a long-standing problem: the multi-year, sometimes multi-decade wait for family visa numbers in oversubscribed categories. With the termination of these programs, individuals who entered under categorical parole must now determine their status options carefully. Some may be able to adjust status based on underlying approved petitions. Others may face departure requirements. The analysis is genuinely fact-specific. which is why this development requires individualized legal consultation more than any other change on this list. This could affect you even if you are not in one of these specific countries or parole programs, because the terminations signal a broader policy direction around humanitarian parole that may affect similar programs going forward. All right, you now understand the landscape. Let me give you a structured action plan. Step 1. Audit your current status immediately. Sit down and document exactly where your case is, the form type, the receipt date, the current processing stage, and the expected timeline under normal circumstances. Know your baseline before any consultation. Step 2. Verify whether you, your co-applicants, or your petitioner are nationals of any of the 19 countries under the Presidential Proclamation or the 75 countries under the State Department immigrant visa. Pause. If yes, flag this for your attorney immediately. Step 3. If you are in a premium processing eligible category and you have not yet evaluated whether the cost is justified for your timeline, do that analysis now, especially in light of the March 1st fee increase. The window before additional complications arise may be shorter than you expect. Step 4. H-1B registrants. Work with your sponsoring employer to document and formalize your prevailing wage level in writing before any registration is submitted. Under the new wage-based model, your salary tier directly affects your selection probability. Step 5. Consult a licensed immigration attorney before taking any action, including travel, filing, or withdrawing applications. The interaction effects between these 5 policy changes are not always intuitive. An action that seems safe in isolation may have unintended consequences in the current environment. Do not attempt to navigate these developments alone, and do not rely solely on sources that lack legal grounding. The cost of a misstep in the current climate is too high. Before I close, I want to give you the honest policy context, because staying informed means understanding not just what happened, but what comes next. Several of these actions, particularly the Presidential Proclamation and the immigrant visa pause, are already facing or expected to face legal challenges in federal court. Courts reviewing executive immigration authority under Section 212F of the INA have historically given significant deference to the president, but that deference is not unlimited. The administrative procedure challenges may generate different judicial responses. Congressional action is also possible but uncertain. Some legislators have introduced or signaled intent to introduce measures that would codify or counter aspects of these changes. Whether any such legislation can advance through both chambers and receive a presidential signature in the current political environment is genuinely unknowable at this stage. What I can tell you with confidence is this: the pace of immigration policy change is not slowing. The period we are in right now requires ongoing monitoring, not a one-time check. What is true of your case today may be different in 90 days. I want to be clear about what immigration status actually means in people's lives, because sometimes in the policy discussion, we lose sight of the human stakes. Immigration status determines whether families live together or apart. It determines whether you can work legally and build financial stability. It determines whether you can travel and return. It determines your path, or your children's path, to permanent residency and eventually to citizenship. These are not bureaucratic abstractions. These are the foundational conditions of people's lives, and the 5 policy developments we have discussed today touch every one of those conditions. Take this seriously, be proactive, and above all, get accurate information from credible sources. That is exactly what I am here to provide. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this video helped you, please leave a comment below and tell me your visa category. Whether you are family-based, employment-based, or navigating the humanitarian parole changes, I want to know what is most relevant to your situation, because that guides the content I create for you. If you know someone who is navigating an immigration application right now, share this video with them, not because I need the views, but because this information could genuinely change the outcome of their case. And if you believe in factual, grounded immigration coverage, please give this video a like. It helps this analysis reach the people who need it most. I am Raymond Crivello. Stay informed, stay protected. I will see you in the next video.